Good afternoon. I'm Robert Aronoff, a member of the Executive Committee of the Bankruptcy section of the Beverly Hills Bar Association. I am Program Chair for today's webinar entitled After Barton Will.
I think Bob just got cut off when he tried to say Bartenwerfer.
It's hard to say, I know, but
Bob, we missed your introduction. It was great, but you just
Well, my screen just popped up that my internet couldn't handle that word either. It was a brief in the internet. So hopefully you can hear me now. Our program is being recorded and will be available in a couple of days in BHBA On Demand, the Beverly Hills Bar Association's newest member benefit, presented by Lawyers Mutual Insurance Company. You will receive your MCLE certificate shortly after our program concludes. Your certificate will also be stored in BHBA's Plus, our members-only community. Finally, please take a moment to complete the survey that will be included with your certificate. It really assists us in continuing to provide quality programs. Before I introduce our speakers, let me remind you of the benefits of being a member of the Beverly Hills Bar Association. Not only do you get more than 200 annual seminars and webinars similar to this one, but there's also on-demand online MCLE programs, networking opportunities, and numerous practice section areas. And now we are providing our members with video profiles for their social media. There's so much more that you need to go to our website to see it all. Best of all, there's membership packages for everyone. Law students and attorneys in their first 3 years of practice are free. After that, packages cost as little as $20 a month. Our speakers worked very hard to prepare the detailed slide deck to which they will be referring. It contains citations and more information than they are going to be able to have time to tell you about today. They will be moving rapidly through it. You were sent a copy of with the confirmation for this program, and there's a link in the chat to download the materials if you still don't have them. So you might want to follow along and take notes on your own copy. So now let me tell you a little bit about our speakers, to tell you all about their qualifications and accomplishments would leave little time for them to speak. The materials you were sent have much more detail on them. Judge Barry Russell should be familiar to most of you. He has served on the BAP and was a former presiding judge of the Bankruptcy Code of the Central District of California, where he is currently serving as not only the longest serving bankruptcy judge in the district, but in the longest serving bankruptcy judge in the nation. He was asked to join our program today because he has extensively researched and written articulate and notable opinions on the fraud exception under Bankruptcy Code section 523A2A. Iain Macdonald has practiced bankruptcy law for over 50 years, primarily in the courts of the Northern and Eastern Districts of California. Mr. Macdonald attended the University of San Francisco School of Law and has taught bankruptcy and commercial law there since 1984. Mr. Macdonald's current practice is all about bankruptcy, whether it be complex Chapter 11 or a business reorganization. He is famous for his out-of-court workouts and bankruptcy alternatives. He also mediates, functions as an expert witness, and advises on asset protection. We asked Iain to speak today, not just because he represented Mrs. Bartenwerfer in the Supreme Court, but because he has some fascinating insights concerning what it is like to take a case any case, all the way to the Supreme Court. Scott Bovitz is a bankruptcy litigator in Los Angeles and is a board certified specialist in bankruptcy law by the American Board of Certification and the State Bar of California Legal Specialization. And he formerly chaired both organizations. He's a frequent speaker, not just at the Beverly Hills Bar Association, but at numerous bar associations throughout the country. Every year, he is selected as Southern California's super lawyer in bankruptcy and creditor debtor rights. Scott is coordinating editor of the American Bankruptcy Institute Journal. And Scott also teaches at California Western School of Law. Last year, he taught at the University of Nevada in Las Vegas. And in his spare time, he's an accomplished photographer, composer, and music producer. Next week, Scott will be honored as being inducted as a fellow at the American College of Bankruptcy. Our speakers have a lot to tell you. If you have questions, please use the Q&A feature at the bottom of your screen. At the end of the program, we will get to as many questions as we have time for, but if we don't get to them, do your question, we will, you can email the speakers and they'll be glad to answer them for you. So with that, let me turn this program over to Scott, and you can begin.
So Judge Russell reminded me that he was in the American College of Bankruptcy Class 1. So, you know, he's been the man for a long time in the classic sense.
I don't know if you noticed, we're in my chambers and Iain's in San Francisco, right?
Yes, that's right. I'm here.
Okay.
See the beautiful weather?
It's a magic of Zoom. And you clearly have a friend or two because somebody's already texting you there in the background in connection with this. We've got a kind of an interesting problem. Okay, Ken Klee is a fan of old 1800 bankruptcy Supreme Court cases, and you know we all know they can't really mean all that much, right? If you have something from 1877 discussed in an important case in Re Huh, H-U-H, which originated with Judge Russell down below, you have a case from 1877 that talks about the imposition of fraud on a partner between partners, and then Strang versus Bradner. Boy, that's a case. We're talking on slide 8 on our little slides, the numbered slide, not the introductory slides don't have numbers. In Strang, there was a partner who was responsible for the other debts of another partner. All right. That's not very complicated. So liability and damages are assessed against the partner. But the question was, at the Supreme Court level, under a pre-bankruptcy act temporary thing, you know, was the claim of the person who was vicariously liable for the bad partner, was it non-dischargeable, if we could even use that phrase back then? Mr. Macdonald, are we really going back interpreting something from 1885 when we're talking about what really is today a modern issue under 11 U.S.C. section 523A2A? Macdonald, go.
Yeah, I was surprised when the other side cited it. I thought, are they kidding? They can't bring up these old chestnuts and expect they're going to get anywhere with them. And obviously I was wrong. Yeah, very much. The Supreme Court cases are, you know, worth their weight in gold. So they did rely on them.
The issue, of course, for non-dischargeability, everybody gets to file a proof of claim and participate in a bankruptcy case. And if the claim is allowed and there's some money in the bucket and the priority is such that it hasn't all been used up, you get either a pro rata share, or maybe you get all of it, depends. But assuming you don't get all of it and you're a creditor, you would like to have the balance of your claim, the money you don't get from the bankruptcy case, to be non-dischargeable.
Exactly.
U.S.C. section 523 has a number of exceptions. a common one, Judge Russell, wouldn't you say maybe the most common one is one where someone alleges that their claim arose from fraud?
Correct, 523A2, that's correct.
Judge Russell's always going to do is say, we're right today. It's great. You know, he's.
Unless you're not, of course.
So the issue is, of course, this is the question, and Mr. Macdonald raised this and said it's all right. False pretenses, false representation, or actual fraud of whom? A discharge into section 727, okay, that's chapter 7, does not discharge an individual debtor. We know corporations in chapter 7 don't get a discharge of a claim arising from, I'm adding that, for money, property, services, or some other stuff to the extent obtained by, that's kind of weird language, isn't it? It's kind of passive kind of language. False pretenses, false representation, or actual fraud. Then there's an exception that talks about a financial condition representation, because that's dealt with in not this program under A2B in connection with that. So the question is, of whom? Macdonald, right?
That's right. And that word you use, passive, is very much the subject of the Bartenwerfer decision, because it doesn't say who the actor is. It's in the passive tense. And so it just kind of leaves a blank for you to fill in and identify the actor, the one who is the fraudfeasor.
So just to set the stage in connection with this before we actually get to the guts, which is, Bovitz, what's the Bartenwerfer decision say? Why do we care? The key decision in this jurisdiction that arose from a trial decision by Judge Russell was in re ha, H-U-H. And we're not going to read through all the slides, but just so you understand the issue was whether a broker was responsible for the admitted misrepresentation of a salesman in a real estate transaction. Now, that's not the subject of the Supreme Court case, which deals with partners, though they became husband and wife, but they initially were held to be partners with respect to a single asset real estate flip. I'm not using single asset real estate in the Chapter 11 sense. I'm using it in the sense that it was a partnership first and then they got married. And the standard that the bankruptcy appellate panel applied when there was an appeal from Judge Russell's decision was, well, if you have someone who knew or should have known with respect to the fraud of this other person, then they could be vicariously liable. And if you don't, then they can't. And that's a question, Judge Russell, for the bankruptcy judge. At least it was, right? You decide that.
Right.
Everything Judge Russell's going to say is going to be like that today. No, it's liability and damages. That's a state court determination for HUD because there was a state court judgment. And we apply, do we not, Judge Russell, in bankruptcy court, what we used to call collateral estoppel with respect to issues of liability and damages, right?
Well, yeah. Well, let me tell you what my view had been, and I did write a lengthy opinion. You have it in there somewhere.
We are going to talk about it.
And hey, my opinion was prior to the Supreme Court case, and Scott and I had done a previous program. Like I said, what, for the San Fernando Valley Bar. And
we had some opinions.
Right. And I was, until I read this opinion, absolutely sure it was a slam dunk for the debtor in this case. And why? Because it was always my opinion that not only in the 523A2, which is in the passive voice, but there were some recent Supreme Court cases that weren't in the passive voice.
Bullock,
523A4, and others, which all held that you had to be a bad actor. You had to have some bad conduct. And so it was my feeling, even though it was in the passive, that of course they wouldn't go back to the 1800s to rule on the case, because a lot had happened since then. And so that was my opinion, and in Chart as well. And I'll leave it till later in the discussion. I was astonished until I read it.
Okay. So don't hold your thunder for a second.
Okay, no, I am.
All right. So that was the decision down below. In re ha, they adopted a 7th Circuit, 8th Circuit standard, Walker. Okay, and then Mr. Macdonald Kate Bartenwerfer walks in your door. Tell us, without going into attorney-client privilege, your practice and what you're doing.
Was it my practice and what I do?
Well, I mean, tell us about Bartenwerfer, how that fits into your world. Are you a Supreme Court litigator by trade?
No, I never had the wildest dream that I'd be in the Supreme Court. In fact, I just joined the Supreme Court just because there was a convention in 2019, and the local bankruptcy judge invited a bunch of bankruptcy lawyers to come and be sworn in, which I did. I didn't even know if I should have spent $250 to do it. But then when this case came up, suddenly I was able to sign the brief, and I was a Supreme Court lawyer. That's how it came about.
So you tried a case down below before Judge Blumenstiel, right?
Yes.
And there was a state court determination, was there not, before this by
Yes.
judgment creditor Buckley, that said that, hey, you guys, there was some misrepresentation with respect to the sale of a house, and the misrepresentations were by, let's call him David, okay, and Kate, the other person, just to be simple here, because we've got two people and it's complicated with the names. David made some misrepresentations, the state court held it so, and then the question was in bankruptcy whether I'm going to call her the innocent spouse, the one who didn't have any actual knowledge of the misrepresentation, should be responsible. Have I teed that up right?
Right.
But there was also, because they were partners prior to being married, but they then were still partners under the state court judgment, they were liable. If you're a partner, you're liable under most state laws. California is certainly the case. You're a partner, you're stuck, whether you knew about it or not. That was the underlying judgment in the state court.
Right. So the series of slides leading up to slide 20 talk about that lower court activity. It went up on appeal, it was remanded, and it went up through the BAP back to the Ninth Circuit. Was there a direct appeal at the end, Macdonald?
Yes. Yeah, there was a direct appeal.
Man, those are rare too, aren't they?
Yeah. Oh, I'm sorry, you mean to the Supreme Court?
No, to the Ninth Circuit from Blumenstiel.
Yeah, was it certified? I think was your question, to the circuit rather than going back to the district court or the BAP.
That's my question.
Yeah, no, it was not certified. We just took a direct appeal.
All right. So now we have at the Ninth Circuit, Macdonald, tell us about this. This opinion isn't even published. It's just a little like a thin, like whatever. Tell us about that.
Well, everyone was, encouraging me and egging me on and saying, look, you've got this. This is a slam dunk. So needless to say, when I walked into the Ninth Circuit courtroom, I was shocked. Everybody was jumping down my throat, and they reversed it almost with a, what they call it, a per curiam. They just reversed it.
It's a very short opinion, a few
Short.
pages, right?
Yeah, and it only cites two cases, Cicchini and one other case.
Strang,
Strang, of course. Yeah.
Anytime you
That other case.
Anytime you read something that's got the 1800s in it and it's the Supreme Court, and I don't know. It just makes me kind of nervous because that's not the Bankruptcy Code. Bankruptcy Code enacted, effective in 79, right, going forward. Okay, we can understand it. And there's 7 years of workup on that. So you have a lot of, of legislative history with respect to the Senate and the House. And we kind of understand the way it goes now. Is that history really important? It's helpful to understand it. It's not law, right? The law is the statute itself. But it was based on the Bankruptcy Act. And the Bankruptcy Act went back to 1898. Judge was not yet on the bench, even though he's the longest sitting judge. And before that, we had various temporary bankruptcy acts during financial distress in this country. And that prior act was not even effective. It was done, and there was no bankruptcy law until 1898. And they went back to something even before the Bankruptcy Act of 1898. Now, Macdonald, isn't that it's just strange, isn't it? Not strange.
Right, that's what I thought, but I guess the lesson I learned is not to poo-poo a case just because it's old. They really pay attention to these old cases. If it's the one they want, got the result they want. So is what happened here.
So now, Judge, you're not involved in this, but you're following because it's interesting and because in the briefs at the bankruptcy appellate panel and the briefs at the Ninth Circuit, in re ha, your case is very much a part of the standard. We're on slide 21 now. Very much a part of the of what had worked very effectively, not in every jurisdiction, but in lots of jurisdictions, knew or should have known. If the person who was vicariously liable knew or should have known, all right, then you're gonna be able to hold you, Judge Russell, going to be able to hold that the person didn't do it, but the person's vicariously liable is going to have a non-dischargeability problem. Their creditor who has a vicarious liability against is going to be able to, under 523A2A, hold it. So that doesn't seem very complicated, does it?
Seems straightforward to me, and I think it's just the nature of the business. We have been in it for a while, feel that in order to have a debt non-dischargeable, unless it's the bad kind of conduct stuff. Obviously, there's some taxes and alimony and child support that not necessarily bad conduct. It is Congress has decided those will be non-dischargeable.
And in fact, A5 and A15 really don't even talk about the debtor. They talk about the nature of the claim. Some of the stuff in 523 talks about the nature of the claim, like alimony. We don't call it alimony, but we're calling it alimony for here. And support, that A15, the other stuff, right? So that focus on that.
And time limits too. That is, there are only 3 types that have time limits. That is 523A2, which is the fraud, A4, which is more confident, that is fiduciary duties, and A6, which is willful malicious conduct. Those 3 are the kind of the bad stuff. Almost
60
anybody.
days.
And yeah, it's a short
Man.
time after the meeting of creditors. First date set for the meeting of creditors. You got 60 days. And the reason for that, whatever in the rules is, those are the real serious stuff that the sort of the bad conduct, and those ones you have the 60 days. And I always thought all of those, the Bullard case that had to do with the fiduciary duties or defalcation was under 4, that's what I thought they too was all about. In fact, as my old friend Erwin Chemerinsky, the dean up at Berkeley, would say, he always questions whether you should really predict what the Supreme Court can do. He says, if you're looking at a crystal ball, you're likely to eat glass. It was a great thing. And that would have been my situation here. I was a slam dunk. I couldn't imagine the court. And yet unanimously, by the way, they decided this case.
So we're almost there. Okay, so Mr. Macdonald, here you are talking to a client. We're not asking what you said or what she said, okay? And they're thinking, well, okay, you're actually representing, I think, both of them, but David was sunk. He made the bad statements, and I'm making this conclusion. So there's no appeal for him. But there's an appeal on vicarious liability of the innocent spouse, Kate. So you have this conversation, and somehow, says, yeah, go ahead and file a petition for cert. Now, I don't even know where to go to get that form. Tell us about your experience.
Well, quite frankly, there's a few things at play. One is that we had nowhere to go. I mean, this was really devastating for the client because Kate is the breadwinner in the family, and she's very vulnerable to enforcement of a judgment. She works as a paralegal for a Silicon Valley firm. I mean, she's a dead duck. So she had to appeal, and plus the fact that we thought that it was meritorious. And also Judge Blumenstiel, the bankruptcy judge, had given us a stay pending appeal. In fact, after the Ninth Circuit reversed, the other side went into Judge Blumenstiel and asked him to vacate the stay. And she said, no. I said, I'd stay it as long as you were appealing, and you're still appealing. And they just laughed. They said, there's no way this appeal is going to go anywhere. And then to everybody's shock, certiorari was granted.
Wait,
so
you and Reno Fernandez huddle together in the room and figure out where the form is, and you figure out where the filing window is, so to speak. Is it all done electronically, or is this like you got to go to somebody who's in a dark room with a single light bulb?
No, it's all done electronically, and you can view the docket. I mean, when they decide the case on Monday morning, you get the word immediately. It's just all right there, just like it is out here in the real world.
Okay, so they say petition granted, and now you're thinking, okay, you've never in your life thought about amicus briefs, right? Because you haven't had to, even though theoretically they could be filed. But the Supreme Court says, no, we'll take some amicus briefs, but they're going to be helpful. And you got a pile of amicus briefs in your support, and you got a pile of amicus briefs along with the opposition brief on the other side. Tell us about that.
Well, I was kind of surprised. In fact, I thought these people were just kind of trying to get in on the action, just try to get their briefs in. Maybe they were hoping they could show up and make an appearance in the Supreme Court. I did not really see that they were adding very much. Of course, I hated the people who filed briefs against us. It was the same thing with the Solicitor General. They jumped in and filed a brief against us.
Hey, hold on a second. So before the government decides to take a position against you, right, in connection with that, you got two sets of law professors who filed really good briefs. By the way, I've said this to you and I say it online. Best brief I've ever read is your opening brief at the Supreme Court. Fantastic. Just
Really? Thank
really,
you.
really nicely done. And so you got a couple of law professors, groups of law professors who file stuff in your favor. You have the National Consumer Bankruptcy Rights Center that deals with, I'm going to call it battered women, but it's a little broader than that, talking about the issue of Kate being a spouse who wasn't in charge of what her later husband, her first partner, then became husband. And then there's Mr. Zuckerman, who had some personal to do in connection with that. So he filed a kind of a personal brief. Anyway, now there's the opposition brief, which is fine and, you know, kind of straightforward and plotting. I'm not saying it's bad brief, but it wasn't there. And then the government takes a position and says, well, we're the biggest creditor in the world.
Right. Yeah.
I thought, wow, Judge Russell, does the United States appear as a creditor often in your court?
Usually only in tax matter or small business administration, they'll have a claim. That's typically, those are usually in Chapter 11 cases. That's where they usually appear.
So anyway, through slide 30, we have some excerpts from those amicus briefs on the Bartenwerfer favor in connection with that. You did a nice thing. We found out that your middle name is Angus, which we thought is really interesting in connection with that. And White and Case. Where did White and Case from? You're a guy who practices, I say, you know, on the street. We're street fighters. We're at the local court. We're regional lawyers, right? And here you are. Why is White and Case involved?
Well, that was a question for you because you prepared the slides. Yeah. And I don't know anything about White and Case, but suddenly they were there. And so that was a question. I thought you would take it off after you saw that.
No, the question, the reason I have this is because isn't it interesting that big firms back east, especially, like to volunteer to help with Supreme Court stuff so they can get a bunch of people on Supreme Court briefs and say, well, we've been to the Supreme Court 42 times. I don't know if that's really their motive, but, you know, it did seem sort of interesting. Like,
no, it is actually the firm was Williams and Connolly in
okay,
DC. Right. It was a DC firm that worked with us on it.
I messed that up and I apologize.
And just while we're on it, one thing I wasn't ready for is that when they granted certiorari, I was getting flooded with emails and calls from lawyers volunteering to help out or do the work for me for free.
Well, that's a great conversation with the client. Hey, you know, you know me and you trust me. I'm not saying what you said. I'm just saying what I would say. But by the way, we have these fancy white shoes lawyers, we used to call them, ready to do the work and they won't charge you. You know, what do you think about that? The client's going to say, yeah, but can't you be a part of my team too? Because the client's going to trust you. You don't have to say anymore.
Yeah.
That's what's going to be happening. Okay. So the issue was on 32. That's not here. The judge's clock doesn't chime.
It chimes, but it's not wound up purposely.
May an individual, that would be Kate, be subject to liability for the fraud of another, that would be husband, ex-partner, that is barred from the discharge of bankruptcy under 523A2A by imputation without any act, omission, intent, or knowledge of her own. And that was Blumensteel. Judge Blumensteel made the determination on the second round of this that, hey, nobody's even saying that she had any knowledge. She had no knowledge. She was, you know, the innocent person. That's the pitch. And then there was this fantastic, compelling paragraph. Bankruptcy once meant consigning families to the Dickensian debtors' prisons until the paterfamilias repaid every farthing. Okay, Macdonald, that's just friggin' beautiful language, okay? It's just great, okay? Talking about the fresh start in life, the honest but unfortunate debtor, citation to a Supreme Court case and Lamar, which is, of course there. So it's all good. Question is who fraud counts, which fraud counts. And I'm going to just go to this. Slide 36. Okay. Judge, we see a guy that looks kind of like Macdonald there on the left, and we see some pretty lady on the right, and they have an umbrella. And do you recognize these people? Oh
No.
I bet one of them was Macdonald. What is this?
These are the steps of to the great court.
And is this the very day that there was oral argument?
Yeah, it was after the argument. We were coming down. We didn't really have much to celebrate because we had just been raked over the coals by the justices in the course of the argument. But
You knew at that point you had lost.
I was afraid it was going to be 9-0. I thought this is going to be really embarrassing, and it was 9-0.
Okay, all right. Wait.
Not one single justice
Hold it.
had a kind word to say.
Hold it. This is fantastic because not only does the Bankruptcy Appellate Panel and the Ninth Circuit broadcast, that's not a sentence, but they broadcast argument, but at the Supreme Court, we can hear in real time, probably with a 5-second delay in case somebody starts swearing or something, okay, like at a football game, we can hear in real time the argument. So we listened to it. And I thought it was harsh, but I thought there was a lot of back and forth, very active court. Did you find it to be that way?
Absolutely. Yeah, I wasn't expecting it. I mean, where else do you get up and argue to 9 justices, all of them well prepared, very smart, and out for bear? And they were just loaded for bear. They all asked questions.
They were all ready for this.
Well, because this is really a simple issue. This is not like a complex, patent case or something. This is anybody can really understand.
They all got into it. It was easy for them, and that's what they did.
Suppose my child is a partner of they would ask great questions. I like the questions. Okay. Then there's a decision, February 22nd. So, not very long ago, there's a decision that's published, available in Westlaw. Justice Barrett. So we have a conservative justice who issued it. You look and you see, is it 5-4 or whatever? It's 9-0. 9-0. And I don't think I really understand the passive voice thing, but here's I think the heart of it, right? The Bankruptcy Code strikes a balance. Okay. The creditor's interest in recovering a particular debt and the debtor's interest in a fresh start. I'm pulling out phrases in connection with that. But sometimes a debtor, here Kate Bartenwerfer, is liable for the fraud she did not personally commit. For example, deceit practiced by a partner or an agent. We must decide whether the bar extends to this situation. It does. This is right at the start of the opinion. And then the justices talk about the passive voice. What does that mean, the passive voice? Macdonald.
Well, what they meant was that the actor was not specified. It just simply said that this particular debt is non-dischargeable. It doesn't say by whom.
Fraud obtained by, it doesn't say by the debtor. And the justices thought, but when I look back at not the Bankruptcy Act, but the act before that's no longer around, they used to say by the bankrupt, we called them bankrupt. So gosh, that must have been an intent to change.
Yeah, exactly.
On slide 38, Judge Russell, they granted certiorari to resolve confusion in the lower courts. I didn't think we had any confusion.
Not in California, anyway.
I didn't think we had any confusion at all in connection with that, but they go through this and they cite the different things, including In re Walker. In re Walker on slide 38 was the decision that got the Bankruptcy Appellate Panel interested, and they put their arms around it and said, that's what we're going to do. Anyway, so that was the list of this. Okay. And then here on slide 39, Judge Russell, this is a lesson on statutory interpretation. We start where we always do, with the text of the statute. How do you interpret the Bankruptcy Code? Just, do you start with the statute, or do you look for some case that tells you how to read it so you don't have to look at it?
No, I'm sort of in the middle of it.
Okay.
I read the statute. And in this particular case, I didn't notice I noticed the passive voice, but in view of Bullard and some of the other cases, I thought it was pretty clear, which is a serious mistake, that Congress ever has an actual intent to do anything one way or the other, depending on what side, how you're looking at it. But it was my sense in reading it that if Congress had a choice, that's what they meant. And quite frankly, I want to tell you that when we've done this program before, when I wrote my opinion in short, I was absolutely convinced, and I can tell you I was wrong. When I tried to put myself into the eyes of the Supreme Court, the three liberals I thought would go the other way, and when those three voted on this, I said, "Whoops, where did I go wrong? There must have been," and I was, because what they did is, rather than with the experience we have in thinking you gotta be non-dischargeable, you gotta do something wrong. That was where I was coming from.
I call it mens rea.
Yeah, the malum and se, as opposed to malum prohibitum is the tax stuff. It's just prohibited because that's or student loans. There's nothing bad about it. But malum and se is something that is inherently bad. And I always thought 523, A2, 4, and 6 were those sort of things. You sort of know it when you see it. And I'll tell you, I hate to admit this, but if I were on the Supreme Court, I would have gone with the majority opinion. Why? Because it's strictly statutory construction. And they pointed out that when the case we were talking about, 18 cases, even there at that point, the bankruptcy law read that even if there has to be the fault of the debtor, in spite of that, the Supreme Court, in their wisdom back in 1895, I guess it was, they ruled that way. And what the 1885. But what they did is they pointed out in the opinion, and I read that, I said, oh my God, and when I wrote my opinion, I had missed that they said that after that opinion, that even though the statute at that point read that the bankrupt in those days, in other words, the debtor, they deleted that. The next statute after that, they said that when they redid the bankruptcy law, that was in 1898, they deleted the fraud of the bankrupt. And if you're looking at it strictly, from the Supreme Court, these are not bankruptcy people, say, well, what did Congress mean? Well, if they deleted it and now have the passive language, they didn't intend to have it. They wanted to go back to the old, partnership law. And it's really difficult. And even the three liberals could not. And I've heard of a moderate myself looking at statutory interpretation. I can't argue otherwise. That when they deleted the actual language that we thought was there, it wasn't there. And so the answer, of course, is, as even the concurrence said, Congress can always change it. And it'd be, I'm interested in, if I'm right, and Scott's right, and Ian's right, that Congress really never really, if put to the issue, would find, not agree with this. It's very simple. And I don't know, given Congress, how they dispute everything nowadays, but Congress clearly has the ability now to go forward and say, no, we disagree with the Supreme Court. We think it should be, it should be bad conduct. They can do it. And we'll wait, I guess, and see if they'll do it.
I don't think, I don't think Congress reads all the statutes that they pass myself. I don't think it's even possible in connection with that. And I can't imagine that you can actually pull congressional intent from this, but they focus on the statute itself, and they said, hey, I got this passive voice stuff on slide 40, and we can throw that out. And yeah, we're looking at the congressional intent, but that's not really what we're looking at. We're looking at the words, and the words say, it doesn't say by the debtor, right? So that's enough. On slide 41.
And that's it. That's what the case decided on.
Well, okay, we can go. All right. No, wait.
No, what's the future is what we're going to talk about.
We got more to say. We got more to say. Slide 41. The relevant, we're quoting from Bartenwerfer v. Buckley. The relevant legal context, the common law fraud, has long maintained that fraud liability is not limited to the wrongdoer. Okay, so, Russell and Bovitz get a little partnership to run a hot dog stand, and in turn what we're doing is we're actually stealing money from people to go by because we're doing an RFID and we're checking their credit cards and stuff like that. If Judge Russell is doing that, it's my partnership and I don't know about it, I'm still going to be stuck with that. That's really kind of problem. I guess I got to look for a better partner, right, in connection with that.
Well, it is California law, is it not? That is the law. Probably, I don't know about other states, but I assume that's pretty much the law of the United States. I know that's the law in California.
I think that's right. But
Yeah, Justice Barrett cites California law and says that's the rule in the state.
courts have traditionally held principals liable for the frauds of their agents. So, Mr. Macdonald, I think we're going to see what has actually been decided versus what's not decided. Liability of a principal for the bad acts of an agent, whether the principal knew or should have known, that's not the standard anymore. That probably fits under 523A2A. Is that right?
I think so, yeah.
And the second part of this, again, from slide 41, is frauds committed by partners within the scope of the partnership. Within the scope of the partnership, that's kind of an interesting to do, because on the Russell Bovitz thing where we have a hot dog stand and you know, Judge Russell not wearing his judge hat is stealing the information on the credit cards going out, that doesn't sound like it's within the scope of my partnership to run a hot dog stand. So, you know, I mean, that's might be your own fraud. I might be able to argue not within the scope of the partnership. But where, Judge, am I going to argue that? Am I going to argue that in your court? Am I going to argue that in the state court when somebody sues both of us?
Well, if you where you'll start would be typically, it could, like we both know, that the judgment may be threatened and then they'll file bankruptcy and then the bankruptcy court will decide. But more typically, as in this case, it would be decided initially in the state court. And that's what the state court did in this case. They were clearly partners. The renovation of this, I don't think they even lived in that particular house. They were going to flip it, but that was clearly the nature. That's what the partnership was all about, is to renovate it, sell it for a profit. So clearly what this fraud was, it was in the course. Yours is a tougher one. You suggested if they steal from the credit cards, I'd have to think about that one. Whether it had to be in the scope.
Those hypotheticals right in the middle of the program that you can't do that. So, Mr. Macdonald, if Kate and David were married before they decided to buy the house and flip it, so they weren't partners, but they would be responsible under community property law for the bad acts of husband or whatever. Does that give a different outcome than Bartenwerfer would be Buckley?
Well, I didn't think it was dependent on the fact that they were married. I thought it was the fact that Dave Bartenwerfer, you know, he was a Stanford MBA and he thought he was a smarty pants. So he formed an LLP so that they would, you know, formalize their relationship as a partnership. But I think
my case, the Shark case, which I did, it's in the material, and I did write the opinion, they were married. That was what, in fact, for going future, I think where this is going to head as far as married couples that do things together, whether they're remodeling homes or stuff. I think that's where bankruptcy people have to keep an eye out. In my Shark case, they were not partners in the sense of, and that's what I had decided. The law was, the BAP had previously decided, if you're a partner, that you can be liable. And I decided under these facts, no, they were not partners on what they did. It was only because they were married. The wife helped out little things, accounting, some stuff, but she really wasn't active in it. And I ruled that that because the mere fact that they were married doesn't make them partners. So I think that will be argued by creditors as far as, let's say in this case they were partners. The Bartenwerfers were partners, and they were obviously engaged or something, but they weren't married at that time. Had this case could have been turned out totally different had they been married, then bought this property to remodel, and everything, the facts were the same, and were not technically partners because they didn't sign a partnership agreement. I think the case would have gone otherwise, because they were married, but they were actually, and I assume they signed the partnership agreement, but they were married, they were partners before they were married. I think it would have gone totally different had they just not signed that agreement.
Or if they had not bought the house as joint tenants, or if they had a transmutation agreement.
Well, but then you would have the question is, is their conduct even though they didn't have a partnership agreement, doesn't make them in effect partners. That would be
Yeah,
a
right.
factual determination.
Yeah.
And under these facts, I would have probably ruled otherwise. I mean, I would have said, no, they're not partners, but that's how it's going to arise in the future.
Yeah, exactly.
No,
Yeah.
Iain,
Oh,
you sound
oh,
like a drummer. when
oh,
you do it,
sorry.
And it's like you're used to the gavel. I could give you a gavel to do that. So
Can I add one other thing? There is a case that's mentioned in here. You show how this.
no, Judge, you can't. Oh,
No.
yeah, go ahead.
No, under 523A19, which I suspect that nobody, except for maybe the three of us, would have a clue what 523A19 is.
Mr. Sherman.
Yes, that has to do with security violations. That's a more, I forget when it was enacted, but relatively, last, 10, 15 years, whatever, I forget when. Fairly recent case, and that to show how difficult it was, even at that time. Without going into the facts, particularly, if you want the site, it's 658 Fed Third 1009, the Ninth Circuit 2011. I was a trial judge in that, and the attorney who was Mr. Sherman for the bad guy got some fees, and the question, he filed bankruptcy, and the question was whether and 523A19 is very similar to what we're talking about now. Would have been the passive voice. It's not very clear. And they filed bankruptcy and they filed under 523A19 a non-dischargeability complaint. And I looked at it for a while, and since nobody alleged he did anything wrong, that was my frame of mind.
He was responsible without intent.
Yeah, he was responsible because the money he was paid as attorney's fees came from the fraud. And so I thought, no way, he's not. This is not, so that was my opinion. And this is to show how really good judges can differ in this. I ruled for Mr. Sherman, went to the district court. I was reversed, went to the circuit, and a vote 2-1, I prevailed. That Sherman prevailed. So it was totally 3-2. Some pretty good judges. It shows you, in that particular statute, I have a feeling that I'm not making any advanced ruling, but my opinion in that is probably leave the Ninth Circuit. And by the way, it wasn't the same Ninth Circuit that ruled against the debtor in this case. So I don't know where that would come out, but I think at least there was some question because it was in the passive voice.
I wanted to point out on slide 43 and 44, that's the discussion of deleting the language that the judge referred to in connection with that. Slide 45 talked about the policy in connection with that, and then slide 46 comes back to pure partnership. And then Judge Russell is getting ahead of ourselves, and this is probably appropriate given this time. Where is the rubber hitting the road in the future in connection with this, right? Slide 47 says innocent people are sometimes held liable for fraud they did not personally commit. Okay, so the question is, where is that going to be? And we think if we're partners and bad partner does something within the scope of the partnership, but it includes some some bad stuff. Okay, the other partner, let's call him the innocent partner, is going to be responsible for that. Probably also because the Supreme Court expressly refers to principal and agents. That would be the same relationship. By the way, when Macdonald and I started school, Judge Russell, when you started school, we had a principal and agency class. They don't do that anymore. We don't even know what a principal and agent is, but we're going to figure it out now that we need to know that. Okay. But does that mean that, we're going somewhere else with, for example, the case of Surakawa, usual spelling with respect to spouses? Now, here's the amazing thing on slide 48. There's a concurrence in a 9-0 decision by Sotomayor, not known for her conservative approach to things like Barrett would be. And Sotomayor says, the court correctly holds that, bars the debt from discharging. Okay, Judge Russell, we understand it. You understand it. That's what it be. But the bankruptcy court found that petitioner and her husband, Kate and her husband, had an agency relationship and that obtained the debt at issue after they formed a partnership. Okay, that was determined in state court. We never had a chance at the bankruptcy court to determine that, but the bankruptcy court adopted the findings in state court, so the bankruptcy court is permitted to do. Okay, the court does not confront a situation. Here's the paragraph that I'm going to ask Macdonald, what the heck does this mean? The court here does not confront a situation involving fraud by a person bearing no agency or partnership relationship to the debtor. Instead, the relevant legal context concerns fraud only by agents and partners within the scope of the partnership. With that understanding, she and Jackson joined in the opinion. Does that mean something with respect to just spouses being obligated? What does that mean, Macdonald?
No, I think it's not just limited to spouses, but I do think in this context, maybe I was too hasty in stipulating that they were partners. Maybe I should have said no way and just fought that tooth and nail. The result might have been different.
You're stuck though, because that's what was found down below in the state court.
Yeah,
Let me ask you, I assume, because it wasn't clear in any of these, that there was a partnership agreement. I'm assuming that prior to them getting married. I don't know that.
no, I don't. Well, at some point they formed an LLP. I don't know if it was, can't remember if it was before or after they got married.
I think it was after. I think
Yeah.
the facts were that they just decided they're going to do it. They're not married. They're just two people. They happen to be in love, I hope, because they're going to get married. And then they get married, but the business relationship, the joint venture, which is really a partnership, exists as a matter of California law because they had business to attend to and they did something and they bought a house and so forth. You know, I wonder about this. A number of people have asked me this question. Yeah, but how did he get these damages when, like, one of the issues was it didn't have a fire escape? Can't the guy walk around the property and see it doesn't have a fire escape? I mean, you know, why wouldn't that have knocked it out at state court?
Yeah, that's what I want to know. I don't understand how you could fraudulently say there was a fire escape when there wasn't, or vice versa.
We had about reliance element, and you're right, but apparently that didn't happen.
So, Judge, you don't care if it's been determined at state court. You're just going to take that. I read the evidence manual, and it says it's a whole big chapter on this.
It's called
collateral estoppel.
Yeah, yeah. It's like there are two related elements. One is res judicata. That just means you got the judgment. But we're talking about collateral estoppel, namely that the facts have been determined, and at least in California and every other state, you have to look to state law, but certainly collateral estoppel. And those facts, again, once those facts are determined, summary judgment's in order, whether you question, like, you know, why this, why that. If you look at, typically, if it's a jury, you look at the findings. If it's a judge, you look at the statement, a decision of the judge. And if that determinant is that they're partners, that's it. That's the ballgame.
So going back in time, which Macdonald wasn't on the ground at that point, but going back to the state court trial where they're anticipating this issue, the state court lawyers should be talking to the bankruptcy lawyers about what findings we don't want to see, so that Judge Russell will have an opportunity to make his own determination with respect to that. So we'll leave some escape hatch, if you will, the bankruptcy court.
Yeah, and I might mention that there were several fraudulent allegations that Blumenstiel did not felt had been established and did not feel bound by. She only limited it to, I think, four of the fraudulent charges.
So that's interesting. So the Judge Russell, you can look at a list of findings of 12 things and decide I'm only going to accept these 6 because this was just dicta or something of the state court judge?
Well, yes and no. What the issue would be, and I had not realized that what you had just said, Iain, you look at what the fraud was, and any one of them would have the whole judgment would have been granted, right? I think the way it was, like in a typical fraud situation, you have damages of X amount of dollars, and even if you only find 4 of them, if the judge finds that any one of those would have resulted in all the damages, I think that's what probably happened in your case. So isn't that right? That if you may lie about a lot of things, but if you had lied about just one of them, that would still result in the same judgment, right?
It could have, yeah.
Could have lied about a lot of things. So we've got a 5-minute window, and I want to wrap it up with each of you talking about this. Macdonald, where does this go personally for the Bartenwerfers? We're not asking attorney-client communication. And then where does it go in terms of what you do when a husband and a wife show up, or a partner and the other partner show up in your in your room, do you send one out so that can only represent one of you? There's a potential conflict because of Bartenwerfer the decision?
No, well, that second one is a good one because I've always noticed that sometimes lawyers file a bankruptcy for somebody and they don't consider the effect on family members, friends, guarantors. And then these poor people come in and say, what's happened here? I'm getting sued for this and sued for that. And I always feel you have to talk to the debtor about who else is going to be implicated. Now, the lawyers might say, well, I didn't represent them. Too bad they're on their own. But I think if you want to give the debtor complete relief, you'll warn him that this bankruptcy is going to screw up things for a lot of people if he doesn't be careful. That's what I think about that. Otherwise, what I tell the Bartenwerfers, they coincidentally called me yesterday and said, what are we going to do? And I said, I'll have to think about it because I don't know. I don't know what they can do.
Is there a petition for rehearing at the Supreme Court? That doesn't get you anywhere.
Well, there is one, you can do it, but it's pretty unusual. I don't know if they've ever
If it's
granted
9-0,
one.
right? It's going to be. That's not going to.
I think you can go to the higher power. Maybe you go to heaven and see if get some divine intervention.
When you got a 9-0 decision from the Supreme Court that says in a 523A2A, you don't need to be, the bad act doesn't need to be by the debtor. The debtor is imputed by partnership relationship, imputed by partnership agency. They're going to be stuck, and Judge Russell isn't going to go through and redecide it. Judge Russell, you wrote Chart, you wrote Sherman, you decided in connection with this, so you've been actively involved in this. Does this mean that you're going to spend less time listening to the debtor's excuse because you think under 523A2A that you can't now?
No, not at all, because most of these are fact determinative, obviously. It's rare. I've had, I think, 3 of them, at least we've talked about, or 3 of my cases that this issue has come up. So it doesn't come up very often. And most of the cases in the 523A2 are just regular, fraud, whether you're borrowing money from a bank, whether you're, and so it's still there is
regular fraud.
We'll say regular, not imputation of fraud, which was
Personal fraud.
Right, personal fraud. Then when you look at personal fraud, of course, obviously you look at, and people say, well, how do you know? Well, like anything in life, you hear, the testimony in the case, and if you believe that that the debtor lied and the other side relied on it, then that's the deal. But I've been in cases where you could have probably 50 judges in the room and the same testimony, and they could go either way because it depends who you believe. And if that's the test, it's not going to be reversed, whatever you do. So I do my best to listen carefully and see who do I believe, and if I believe the burden of proof has been met by the person who has the burden, then that's the result.
At NCBJ, they have a fine program where they say, you be the judge.
Right.
And they take a vote after they lay out the facts, and the judges vote. It's just random. So, Mr. Aronoff, we're going to turn it back to corporate headquarters for your final comments with respect to Bartenwerfer. Thank you, everybody, for listening to us. Go ahead and listen to Bob now. You're muted.
You're muted. There you go. Okay.
Okay, I gotta get my speech in front of me too here. Hold on a minute.
What a great program.
Okay, on behalf of the Beverly Hills Bar Association, I want to thank our speakers for their time in preparing and participating in this very informative and interesting program. I'm sorry we didn't get time to answer all the questions, but the speakers will be happy to respond to your emails or calls. Once again, their contact information is in the materials. You will be getting your MCLE certificate by email shortly. And that concludes our program.
Thank you, everybody.
And thank you. I learned a lot. It was great hearing from me and some of the facts that I didn't know. So thank you very much. And thank you, Scott. And thank you, Bob.
Thank you.
Thank you, everybody.